Thank you for joining us for 3Bs on the Law podcast, hosted by Trisha Barita, Camille Canali, and Susan Dawson. Disclaimer, this podcast is for entertainment and informational purposes only, not meant to provide legal advice, and does not create an attorney-client relationship. Also remember, laws change or they differ by jurisdiction, so this is not a substitute for seeking legal counsel in your jurisdiction on the current law applicable to you.
Hello, everyone. Welcome back to 3Bs on the Law. Today, we're talking about long COVID. Everyone's been talking about COVID for a long time. We've been talking about it on our podcast since early, 2020. We've been talking about employees. They might be sick for a couple of weeks. What do you do? That kind of concept. But as we're learning more and more about COVID, what's happening in some situations is that individuals, even with mild cases of COVID, are having long-lasting effects and symptoms that go on for months. And this concept is being called or referred to as long COVID. So we're going to talk today a little bit about what does that mean? What does that mean for businesses, employers? What is long COVID?
Yeah. And before we get into why it's important for these businesses, employers to really understand this concept that the Centers for Disease Control and Prevention, CDC, is talking about, let's talk about just some of the possibilities that they've explained as, potentially long-term effects creating this long COVID. And it can be both physical or mental or a combination of both, which makes it pretty tricky, I think, for the physicians even to try to diagnose how long is this going to last, and is it more of a long-term issue for the actual person. So examples of common symptoms of long COVID, they say, according to CDC, includes tiredness or fatigue, difficulty thinking or concentrating, that kind of brain fog that we've heard about over the last year, the shortness of breath or difficulty breathing, headache, dizziness on standing, this heart palpitation issue where you have like a fast beating or pounding heart, chest pain, cough, joint or muscle pain, depression or anxiety, fever, and then the loss of taste or smell, which we've heard, for some people has taken a long time to return or has not returned. And then while the CDC says, of course, the list is not exhaustive, which they're probably just like, we have no idea what's next, right? That we've all heard all along. The research is ongoing on all of this stuff, but some people have actually experienced, damage to their multiple, organs, including the heart, lungs, kidney, and skin and brain. And so there's been effects related to that as well. And so why does all this matter? I mean, I'll let Camille kind of get into it, but it's important for employers to sort of start to figure out what exactly is going on with these individuals that had COVID, and now do they somehow qualify for a disability?
Right. And so under the ADA, this is why we're talking about this, is employers are now starting to see claims for disability from these symptoms that are being attributed to long-term COVID. And that brings up, I know we've done other podcasts about disabilities and the documentation and stuff that's required. But, under the ADA or federal law, your life activities have to be substantially limited by your symptoms. Which is a little bit of a different standard. Of course, California, everybody knows, always has a little bit, employees have it a little bit easier. And in California, you only have to have a limitation of a major life activity. It doesn't have to be substantially limited. So that word substantial is not in California. So it's a little bit easier for employees here in California to make a disability claim. And so employers, because this is a new disease, haven't really seen claims from long COVID too often until now. I notice more and more employers are starting to see these. And so, Susan, why don't you talk about some of the ways that their employees' life activities are coming to fruition and starting to affect employees' work?
Sure. So, with any disability, it depends on your job duties. It depends on, you can have something that substantially limits a major life activity, but doesn't affect you at work. So, for example, loss of taste might not affect the average office workers. So they might have a disability, but it's not something that the employer is really having to address. But Trisha, you mentioned the brain fog, and that's one that we're hearing, over and over again. It's got to be hard for doctors to diagnose, right? And but it does appear to be a real side effect of COVID that is occurring from time to time, and that would impact your business. That would impact your work. So, if someone who is experiencing memory lapses or brain fog, how are you going to accommodate that? What is a reasonable accommodation for that situation? And that's something you'd have to talk about, giving them maybe more breaks. Maybe they need a reduced hours for a period of time. Just with any accommodation request, you're going to have to go through the interactive process. You're going to have to say, what are you asking for? What is your doctor asking for? And let's talk about what's reasonable, and let's engage in that conversation. So it's really going to depend on, what's your job and how is that symptom isn't actually affecting it, right? And it's not always going to be a disability. It might not. Your symptom might not. It might not rise to the level of a disability. You could have a long-term effect of COVID that is not a disability. So it's not always automatically a disability, but if it's impacting a major life activity, and which is requires an accommodation of some sort in order for you to perform your job duties, then, or I should say a reasonable accommodation, right, to perform your job duties. I'm always talking to employers, and they say, well, what accommodation do they need? And I'm always like, let's talk about what reasonable accommodation, right?
And so kind of talking about, you mentioned the loss of taste, and I was thinking, well, if the guy is lucky enough, lucky enough to be an ice cream flavor mixer and he can't taste the flavors, that may be a complete disability, and he may not be able. There might not be a reasonable accommodation that you can make for that person. But if you have the person that's responsible for mixing all the ingredients in each batch, that probably is not a disability under the ADA, or potentially even in California. It just depends, like you said, Susan, on the job duties.
Camille, I was like not thinking ice cream maker. I was thinking sommelier, like someone who gets to actually taste the wine and distinguish, which would obviously be a major issue for them. But yeah, I mean, the analysis is going to be the same when you're doing this whole thing, of course, with the Americans with Disabilities Act, or however it is in your particular state and the disability laws for the state law. You're going to be having to follow the same sort of track that you normally would for whether or not it's going to qualify for a disability. In that analysis, of course, now you've got another issue that comes about is, now do these individuals that have long COVID now have a potential disability? If they truly qualify for a disability, what's the reasonable accommodation? And maybe it's too much of an undue hardship because what they have is now a potential threat, which to the safety of others or themselves in the particular position they're in. So if you have someone that now gets dizzy because of long COVID and they are operating heavy machinery, well, guess what? If you go at least under the federal level with the Americans with Disabilities Act, and you do that direct threat assessment, you're going to have some problems putting that person. And there is no really reasonable accommodation to having them be put in that place now. Because of course, then you're threatening the safety of themselves and others. So it is going to be a tricky issue that employers have to work through. Certainly don't rush to, like Susan was saying, the accommodation immediately. It's so exhausting for employers to go through ADA issues or any of these disability state laws, because it is a process. And I always say this with the disability laws, the reason they were put into place was because what happened before this was that people had disabilities and people just didn't hire them, or they just fired them because they didn't want to deal with the quote determining what an accommodation is, because it's a lot of work to figure it out. And to try to get it right is hard. And so that process now sort of is dictated by these laws, which it is painful sometimes to try to figure out how to handle these situations. And while I know you ladies have the same issue probably, where a client calls and they want to know what's the answer, And unfortunately, there's a process there. And if you don't follow the process and you don't, as Camille would like, document the process, then you're always going to fall short with the courts because they expected you to go through the process because that's the way laws were written for you to do that. So the long COVID is just going to be another big layer of that. And of course, this is affecting beyond just ADA issues. This is going to be a huge issue for insurance because they're not even going to know what to do now with all these new health issues that are coming out of these individuals. All their numbers and trying to figure out how long we're all going to live and how much our insurance costs. Yeah, they're going to be struggling, I think, trying to do that now. So, and that'll of course trickle down to everyone else. But any other last thoughts, ladies, on this one?
And this is also a good reminder that you need to have good job descriptions so that as you're going through to determine what are essential functions of a job and determine those reasonable accommodations, you actually have kind of a checklist of their job duties and responsibilities that you can address with the employee at that time.
Yeah, I'm wondering how this is going to play out in workers' comp, right?
Yep.
If you're in one of those areas where you're presumed to have gotten it at work, and now you have this long COVID disability, that's going to be an interesting one to watch and see how that plays out. So
I think that is definitely, I think that's definitely going to be an ongoing issue in California where there is a presumption that you got it at work.
Right. So
yay, so tricky.
So
fun.
COVID is the gift that keeps on giving. So anyway, we'll just keep monitoring this and keep learning and keep reporting back to everyone. So thanks again for joining us on this episode of 3Bs.
Thank you for joining us on today's podcast of 3Bs on the Law. Don't forget to like and subscribe to our podcast. We also welcome any comments. If you'd like to get in touch with us or suggest a future topic, you can email us at 3THREEBsonthelaw@gmail.com. And because we're lawyers, we need to remind you that this podcast is not meant to provide you with legal advice and does not create an attorney-client relationship. Thank you again for joining us and have a great day.